The bailiff may call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Nathan Illsley versus Janine Fickert, case number 23-AP-352. Representing the appellant, Nathan Illsley, is attorney Stephen J. Howard. Appellee, Janine Fickert, is self-represented and is appearing by WebEx.
All right, counsel for the appellant, please introduce yourself and your client, and you may proceed.
Thank you, Your Honors. My name is Attorney Stephen Howard. I represent Nate Illsley in this matter. So good morning, Your Honors. May it please the court. Given the limited time, I'm going to focus on two areas. The first is found in the brief, and the second is implied in the brief, which is a comparison between the two decisions this court made, one in October of 2022 and again in October 2023. Looking at the issue that was briefed to the court on the question of whether the factual findings of the court support the court's ultimate conclusions of law, our position is that they simply do not. In that decision, the court found that factors 1, 3, 4, and 6 supported Ms. Fickert, while the other factors supported my client. And based on those 4 factors, awarded custody to Ms. Fickert. However, when we look at the evidence in this case, it raises the question, how did the court arrive at this conclusion? Specifically, as the court knows in Casper v. Casper, you held that a court's decision would stand if it's reflected by reasoned judgment of the court in light of the record of evidence. Well, again, going through the actual court records and even the court's own findings, we're left to wonder, how did the court arrive at this conclusion? Specifically, factors 1 and 6 that were found in Ms. Fickert's favor simply not supported in evidence. There's absolutely no credible evidence to place her above my client in these areas. On factor 4, there's one piece of evidence that was presented at trial by Ms. Fickert in support of the concept that she was the primary caregiver, and that was her assertion, I have always been the primary caregiver, nothing more.
Yet, when the appellee left Vermont with the children and moved to Illinois, was there any order in place from the family court?
Your Honor, Ms. Fickert left before we were even able to file, but there was an order issued before we knew that she had left, basically reminding her that she needed to remain in Vermont and not move the children out of Vermont without my client's permission. So therefore, she literally beat the clock. She was out of state before my client could do anything. We then asked the court to seek an enforcement requesting that the children be returned. But again, the court did not avail ourselves of this, and so therefore we were forced to continue with Ms. Fickert being in Illinois despite no order necessarily awarding her parental rights. We actually had to wait several months before we could have that decision. And then we get to March of 2022, and the court was confronted with an accusation of domestic abuse and a court order limiting contact from the criminal court to the children. And so therefore the trial court in its decision in March decided to remain status quo. That is, the children remain in Illinois until the matter could be heard. Come October, we then had a hearing in front of the judge who heard this matter. And at that time, the court, if you review the decision, and I'll talk about this in greater detail, the court found that both parties were equally capable of providing for the children. In fact, the only factor that the court pointed to that favored one party or the other was the one involving the ability and disposition of the party to foster a positive relationship with the other party, and that was awarded to my client. However, the court withheld its judgment on the issue of parental rights until we were able to clear out the domestic abuse claim that Ms. Fickert made, which was dismissed, and we subsequently brought to the court's attention once it had been dismissed. We then had to wait 6 additional months before we could actually have a hearing on this issue. And then the court
Counsel, aside from the allocation of the numbers of the 665 factors, what weight did the court assign to these various factors?
Well, that's the problem, Your Honor. If you read the decision, a good example is if we take a look at factor number 4. Was it 4? Yes. Oh, excuse me. Factor number 3. If you read the court's decision, it actually came up with an equal result. but then determined that she prevailed. I honestly do not know how the court even came to the assertion that the bond with the children to mom was greater than that with dad, because there was no evidence at all presented. And so therefore, oh, and this last thing, since I only have a minute, and if the court will allow me, if we take a look at the decision in October 2022, it was just as likely that my client would end up with the children as Ms. Fickert. We then look at the decision of October 2023, and despite any significant change in any of the testimony, any change in any of the factors, the court awards 3 factors to Ms. Fickert and determines that's in the best interest of the children to remain there, despite the ample evidence to the contrary.
Justice, may I ask just one quick question, Mr. Howard?
Yes,
Yes,
please
Your Honor.
ask your question.
Mr. Howard, the trial court was there listening to the testimony of both the parents and the other witnesses that were introduced. Shouldn't we give some credit to the ability of the trial court to evaluate the in-person testimony of the individual witnesses in creating a decision?
Absolutely, Your Honor, but I would put it to the court that you cannot go into the record and find any factual support for at least 2, if not all 4 factors that ruled in Ms. Fickert's testimony. It's not a question of, do I believe him or her? It's a question of, she never testified to these issues. Or if she did testify, it was a single 1-sentence paragraph. And more importantly, the court found that she was not credible in other aspects of her testimony during the same hearings. So somehow we have to believe that the court extrapolated this from nothing more than looking at Ms. Fickert, because there's no evidentiary support for these factors. And again, I would challenge the justices that are hearing this case to actually go through the record and point out to yourself how the court arrived at these factors. Don't even have to go to the record. Look at the conclusions, the findings of fact, and see how those findings tie into these individual factors. And I think you're going to be exactly where we are, which is,
Thank you.
I have
Thank you,
no
counsel.
idea.
Your time's expired, and we'll have to
Thank
leave
you,
it
Your Honor.
there. All right. Ms. Fickert, please introduce yourself, and then you may proceed.
I'm Janine Fickert. I'm the children's mother. I believe this court hearing was fair and just. I did not have a lawyer. All my evidence was excluded in court. It got thrown out because I don't even know why. I did not have any witnesses. I provided just my own testimony, and I have the evidence that I did have did prove that I was 100% the children's caregiver, the evidence that was thrown out. My evidence was just inserts from my children's medical records that gave no medical evidence no medical information whatsoever. It just gave the children's names, their ages, and who was with them at their visits. And I've provided over 80 responses from the doctors, and they all stated that I was the primary caregiver. I was the one at all the visits, that Mr. Illsley was not at a single one of the visits. He appeared at 2 of the children's medical visits their entire life. And that's because he had to. He had no choice. They had to draw his blood. That's the only reason that he even went to those appointments. I did all the children's medical appointments. I've done all their IEP meetings. I actually have IEP meetings coming up in just a couple of weeks for Morgan and the twins, and I will be present at those meetings in person. I just had to drop everything because Emma dislocated her arm right before visitation for spring. And I was at work and I dropped everything and I left. I didn't even tell my boss. I didn't even ask my boss. I just dropped everything and I left because my children come first. It does not matter to me about anything else. My children are my number one. I bought a house so my children would never have to move ever again. Mr. Illsley rents. He does not own, he rents. So the children would possibly have to move. He also says he can't even afford no more than $50 a week in child support. If he can't afford more than $50 a week in child support, I don't know how he can afford to feed the children. The children eat at least $300 in groceries a week. I do not get any state assistance. The only thing my children receive is Medicaid from the state. Other than that, I pay for their school fees. I pay for their lunches, their breakfasts. I buy food for the house, all on my own dime. I do not get state assistance whatsoever. I know Mr. Illsley would have to rely on the state in order to help care for the children. And I know a lot of the times courts look at that. They look at the financial aspect on which parent can provide for the children without the need of any assistance from the government. And I know they look at the parents, which ones would drop everything. When Emma dislocated her elbow, I asked Mr. Illsley to keep her home from visitation so that way I could take her to the specialist. He refused. That refusal led to her having to be in physical therapy twice a week for 3 weeks, meaning I'm having to pull her out of school to take her to appointments that she wouldn't have had to have if she received the medical attention she needed to receive during spring break. And I have one more. I would like a clarification on page 8 under other parental responsibilities. Section D, it reads, as the children get older, their individual interests may impact the parenting schedule. Each parent should be flexible in making reasonable adjustments to schedule as the needs and the interests of the maturing children require. Now, I read that law and think, well, as the children get older, they're not going to want to hang out with their parents. They're not going to want to go anywhere. They're going to want to hang out with their friends, and they're going to want to do stuff other than hang out with their parents. Mr. Howard has told me that is not the meaning of that law, and that we don't need to adjust the parenting schedule, as my oldest child, Morgan, has decided she wants to hang out with her friends during the summer. She's about to be 13. And I just need clarification on that part of the parental rights and responsibilities. If you guys can provide me some clarification on that.
Right. Do you have any other points you'd like to make? Your time is almost up.
No, I don't have any more points.
All right, thank you very much. Am I correct that the appellant has no time remaining?
You are correct, Your Honor.
Very well.